This case item 1, second appeal 184 of 1993.
Yes, please. Argue?
Yes. Originally, the plaintiff filed a suit for partition of her half share inherited from her husband. That suit was decreed. There is a case of that originally one Radharam Bhandari, he was a common ancestor. He had two sons, Radhan and Gurupada. Now they inherit half share each inherited from their father. Now this plaintiff Putubala is the legally married wife of Gurupada. So after the death of Gurupada, she filed a suit for partition of half of the share of her husband in the estate of common ancestor Radharam Bhandari. Now this suit was decreed by the trial court. Now appellate court, it was reversed. Main ground that now meanwhile both the original plaintiff and original defendant, they died, they have been substituted by their legal heirs. Now this plaintiff after the death of her husband, she adopted this now this appellant as his adopted son. Now after her death, this adopted son was substituted in the suit and he proceeded with the matter. Now, question, their difference is that she is not the legally married wife. One Namita is the legally married wife of Gurupada. So, on that basis, suit proceeded. Now, trial court discarded the version that Namita was the legally married wife of Gurupada because they said that she is still alive, marriage is subsisting, but nobody come forward to say that I am the Namita, I inherit from the Gurupada. So trial court disbelieved their case and decreed the suit that this Putubala is the legally married wife of Gurupada, so he is entitled to inherit the half share from her husband Gurupada. Now this was reversed by the appellate court. They says that there is again that story that Namita is the wife of Gurupada. Now it is the defendant's case. If it is onus upon the defendant to prove that Namita is the legally married wife. Now that cannot be shifted to the plaintiff unless some evidence is laid by the defendant to prove that there is a existing marriage with Namita. So without any evidence led by the defendant, the onus cannot be shifted to the plaintiff that Namita, defendant says, the witness or the defendant says that Namita is the legally married wife of Gurupada, so they cannot inherit. And so far the adoption is concerned, also they have questioned that regarding this adoption, that this adoption was made for the inheriting the property of the Gurupada. So this adoption is a doubtful one. So far the adoption is concerned, it is also, apart from formalities, so a registered deed, this appellant was adopted by her adoptive mother, Putubala. And one more thing is there that they said that they have been suffering from leprosy, that's why they cannot disbelieve the adoption. So Now it is a curable disease. They can live in the society. They can live normal life. So it is a 19th century concept. But she was suffering from leprosy. That's why she has nobody can give him his son in adoption. No, nowadays this is not all this curable disease. So this plea cannot be sustainable. And so far adoption is concerned, it is by registered deed of adoption. So under section 16 of the Hindu Adoption and Maintenance Act, read with section 8 of the Act, that a female can adopt the son or a daughter It says adoption was made after the death of Section 8 is also given this. Hindu Adoption and Maintenance Act 1956.
Is this the finding that the female cannot adopt?
No, no. That's only that she was suffering from leprosy, so that this belief adoption is not deliverable.
What is the substantial question of law?
Substantial question of law, whether the findings of the learned appellate court is vitiated for making out a third case beyond the pleadings of the parties.
Yes, just hold on. What is the finding of the court beyond the pleadings of the parties?
Beyond the pleading, that is just pure suit for partition of half share. So this adoption deed was never challenged in the, by at any point of time. They are defended. So when this Kutubala died,
You see, the adoption deed came into picture because of the reason that somebody was claiming. So unless the genealogy or the family members, etc., is decided, that is absolutely the adoption would certainly come for consideration. Where is the third case? Third case हमको नहीं मिला. I was trying to find out what is the third case. Adoption will certainly come into picture because if somebody is claiming through somebody as a son, then that has to be decided. Suppose there is a partition deed and somebody claims that he is not the son, then that has to be decided in a partition deed whether the person is the son or not. In all the partition suits, it is not necessary that genealogy will stand admitted. Genealogy can be disputed, and if whenever there is a genealogy in dispute, then this has to be decided in the partition suit. So therefore, what do you say? What is it that it is beyond the pleadings of the parties? I am not able to get it. So which is the third case which has been made out?
Actually, I also faced some difficulty because it was admitted from Patna and transferred to Ranchi. So
Sir, वो सब difficulty का कहानी मत सुनाइए. अब आप you are representing the appellant, so you tell us. Either I will say that so far as third case is concerned, you have nothing to say. There is no third case made up. It has to be decided as to who is the son, whether adopted or natural or whatever.
Straightway, whether she is entitled to inheritance and partition,
Yes.
and whether this appellant is the adopted son of the plaintiff or not.
So that parties joined issues on that. So no third case as such is made out. Initially, who were the parties to the suit?
The original party was this Kutubala. They filed the partition suit.
Just a moment. Partition suit was filed by
Kutubala Dasi,
Jittuwala.
widow of Gurupada Kandara.
Just a moment. Original plaintiff is Pattu Bala Dasi, right? So, and the point in dispute at that point of time, which emerged, was whether she is the legally married wife.
Legally married.
Wife of
Wife of Gurupada Bhandari.
Gurupada Bhandari, right? And then after her death, she was substituted by
Ajay Bhandari, present appellant.
primarily on the basis of this registered deed of adoption.
Registered deed of adoption.
Okay. Then before the trial court,
Whether it is the finding.
what were the issues framed by them?
Para 3.
Issue number 3 and 4.
3 and 4.
Right. And both the issues were decided in favor of the plaintiff. Rather, all the issues were decided in favor of the plaintiff.
The victim title decided that House 7 yes.
That's right. The property belonged to common ancestor, namely
Radharaman Bhandari.
so that issue was incidentally it was required to be gone into. Once there is a dispute, that was required to be gone.
Because it has to be resolved.
It has to be resolved. So the parties joined issues on that, and ultimately it was decided.
And they laid evidence and decided.
Yes. So far as the first appellate court is concerned, so there is no point regarding making out a third case. It is not a third case. Right? Now, and the reasons assigned by the appellate court is in reversal for judgment. Whether the reasons assigned by the appellate court while reversing the judgment is tenable in the eyes of society. This part is there. What is the reason assigned by the learned first appellate court in reversing the judgment?
So for adoption, that indirectly by implication they have admitted. Tuvala can adopt in view of section 8, section 16, when it is registered deed of adoption.
So adoption was sustained.
Adoption system. Hold that Ajay Bhandari is the adopted son of Tuvala.
Where is the finding? What are the points for consideration? Then the same points were considered again. Yes. Then, okay, issue number 4 was decided.
to the question of whether the place of death of Procedural.
Okay, so the court said that even if there was adoption, it was Pitubala who could have adopted it, but that will not mean that her husband had also adopted.
Because
Adoption was after her,
after his death.
after his
So
death.
section 8 it is permissible.
That's right. What about this, the other part? Whether she was a legally wedded wife? Parananda. Issue number
Page
3.
15. Does I find that the evidence about marriage of Pitubala with Mangal is not fit to be believed? When the marriage itself is in dispute, it must be proved by cogent and reliable evidence that marriage was performed on account in accordance with the custom and law. The evidence on point of marriage according to custom law is not sufficient. More mere living like a husband and wife does not suffice the requirement of law. A man may maintain a careful mistress, but she cannot acquire the status of wife. Under the Hindu law, a marriage is also sacred and it must have been solemnized under the custom and presence of one of the parties. No evidence has been laid by the plaintiff respondent to show that any relationship or customary union was performed. Moreover, the circumstances that have appeared in this case also suppose that such marriage could not have been performed. The statutory marriage has only been invested to the property and to dislodge the natural heir from succession. It is admitted that Gurupala Mangal, alias Mangal, was a leper. Kutubala was also a leper. Both used to visit Bugandi clinic for their treatment. In this connection, the evidence of PW 6 may be referred to. Witness is evidence. Para 2 has stated that both were being treated as Bugandi clinic. The statement of PW 6 was younger brother of Kutubala gives support to the defendant's case. Moreover, it is against the natural conduct of a man to have agreed to give his son in adoption to a leper. Some steps can be taken only when some material interest is involved. The conduct of Supal Bhandari is keeping Kutubala at his residence also suggests that the story of marriage of Kutubala has been invented. Finally, so on consideration of all entire evidence on record, I find that the appellant respondent has not been able to prove the fact, prove that Kutubala was legally married wife of Mangal Bhandari. This is therefore decided in favor of the appellant and against the plaintiff respondent. Though they learned lawyer opinions, if a man and woman live like husband and wife for pretty long time, such a 50 years so and so, this evidence of cohabitation and offspring out of their union, such evidence of circumstances is on no such evidence of circumstances is on record, and therefore it does not help the respondent in any manner. This issue is therefore decided in favor of the appellant respondent. And lastly, so in my view, the adoption only been made evidence to grab the property of the Mangal Bhandari by Supal Bhandari, who is architect of the entire episode. These are being played in the book. In 5 and 6 there is no dispute about the unity of title and possession over the suit property, but the plaintiff respondent is not entitled to half share in the property of, as Puttiwala had no right to adopt Ajay Bhandari as wife of Mangal Bhandari, and when Ajay Bhandari could not have been legally adopted by Puttiwala as wife of Mangal Bhandari, there is also no cause of action. The issue are decided in favor of the appellant. That appeal is allowed. Now,
Yes, what do you have to say?
now this is that adoption in view of section 8, reading section 16.
You see, adoption has been
Adoption,
you forget about it.
Marriage.
What is the perversity? You say, and the reasons assigned by the appellate court in reversal of judgment of the trial court are not tenable in this. Which reason is not tenable? According to
The
you?
question is evidence that PW11 is the son of the priest who got married this Puttiwala with Gulpadu. Now his son was also present there along with his father. Now he deposed in this case before the court regarding the marriage of
He has deposed.
yes,
PW11.
11.
Where is the discussion of PW11 in the appellate court?
Appellate court just touched on
Where is that? Where is that? PW11. PW11 is one Kashinath Pandey. He has stated that he is a priest by profession and his father was the priest in the marriage of Puttiwala with Mangal. He claims to have attended the wedding. Correct?
yes.
PW11. This is the and where is the discussion in this connection? PW9. There is no discussion of PW11 in the finding. Is there any discussion of PW11 in the finding?
In appellate court it is the matter.
You see appellate court at page number 9,
Yes.
right? At the end of the submission of the just at the end, around 4-5 lines from bottom. PW8, PW9, then PW11.
There is one Kashinath Pandey. He has stated that he is a priest by profession and his father was priest in the marriage of Puttiwala with Mangal. He claims to have attended that marriage. Now this is they have taken. Now at the
So, but there is no discussion of PW11 in the body of the judgment thereafter.
body of the judgment, they say that it is the nephew of.
Where is it? You see, this is a part of the submission,
Yes.
right?
Yes.
Where is the discussion of PW11?
The PW11 that evidence that is taken note but never discarded.
Never discarded. Okay, fine. What about the trial court? Trial court has relied upon PW11.
Yes. Trial court at page
PW11 is PW11.
Page 5, DT.11 is Kasinath Pandey of village Vivodi. He has been examined by say that his father Surendranath Pandey was the
I am not
priest.
able to get PW11. At page 5 of the trial court judgment.
Trial court judgment.
It is at the middle. What is the line number?
Just the below middle.
Just below. PW8. I am not able to find out. You give me the line number.
So this type of
Count it and give it.
this paragraph 4,
Paragraph 4,
next
internal page 5, and there.
then in the middle PW11 is Kasinath Pandey.
At page number 4 or page number 5?
It is paragraph 4 is written in typed copy, that's why you will hear this little difference.
I can see PW3, I can see PW2, I can see PW8.
That is paragraph 5, paragraph 2 and but plaintiff starts with the plaintiff has examined PW 9, 10, 11 was deposed as eyewitness of the point of marriage.
Into the please let me know where it is. LCL. You just mark it, pencil it. What is the name of PW11?
Kasinath Pandey. It's page 4, paragraph 4 in the middle.
What? Yes. Okay. Read it please. PW11 is Kasinath Pandey.
Kasinath Pandey of village Vivodi, he has been examined to say that his father Surendranath Pandey was the priest of village Manjula and he performed the marriage of Putuvala Rasi with Mangal Pandey. He has also said that he was present with the father at the time of performance of marriage. All the three witnesses have been cross-examined at length, but their evidence and the point of marriage has not been successfully taken in the cross-examination.
9, 10 and 11.
9, 10 and 11.
So far as the appellate court is concerned,
Yes.
okay, 11 they have not considered. What about 9 and 10? Because there are 3 witnesses on the marriage, eyewitnesses.
PW9 is page 9 of the appellate court judgment.
PW10. Yes, all the 3 witnesses have been mentioned. And this,
This PW9 Savitri Devi is the mother of Putubala. She has stated that her daughter Putubala was married with Mangal Bhandari. She has also stated that after marriage Putubala started living with her husband. PW10 is Supal Bhandari. He has stated that Muthuwala was wife of Mangal Bhandari. PW1 is Kashinath Pandey. He has stated that he is the priest by profession and his father was priest in the marriage of Muthuwala and Mangal. He claims to have attended the marriage. On the other hand,
Merely because there is inconsistency regarding her place of death, that will not decide the factum of marriage. This part is purpose.
Died at hospital or some other place during treatment.
And PW11 is not discussed at all.
Because he is the independent witness.
That's right.
Rest may be the mother or brother, but
He says that PW 8, 9 and 10 are interested witnesses. Okay, fine. But so far as PW 11 is concerned, that is not discussed anywhere.
no finding given that there is any personal interest or
Yes, respondent. What do you have to say? So far as adoption is concerned, that was incidental. You forget about the first part of the substantial question of law. Because it is not a case, has in third case been made out? No. बताइए substantial question of law में क्या बोलना है आपको? You read your substantial question. Read it please. या नहीं है आपके पास? बताइए. सेकेंड अपील बहस कर रहे सब्सटेंशियल क्वेश्चन ऑफ लॉ का अर्थ पता नहीं है. साथ में मुस्कुरा भी रहे हैं. I have nothing to say. दीजिए मैं एक को दीजिए.
Whether the finding of the Garnet appellate court is vitiated for making out a third case beyond the pleading of the party.
Third case तो he has also agreed कि third case का कुछ कहानी नहीं. Okay, all the issues were incidental and very much there in the case. And whether the आगे पढ़िए.
The finding is, my lord, the issue number 3, which was given by the Garnet trial court, that has been, my lord, that has given, my lord, has been reversed. And my lord, we kindly see that the Garnet appellate court has, my lord, considered the evidences of.
You show me the consideration of PW11.
PW11
is absolutely an independent witness, the son of the priest who had performed the marriage, and he was there at the time of marriage. He's eyewitness to the marriage. Rest of the witnesses are interested witnesses.
The appellate court, my lord, has considered.
PW11 का consideration दिखा दीजिए. इनका केस अभी डिसमिस कर. PW11. appellate कोर्ट में PW11 का consideration दिखाइए.
PW11 is now the Kashinath Pandey. ये जो स्टेटेड डेट भेजिया गांव में भंडारी लोग मेरे जजमान हैं, दीपू भंडारी को मैं
नहीं उसकी नहीं बोल रहे हैं. एपेलेट कोर्ट में उनका डिस्कशन लिखा है।
डिस्कशन तो नहीं है, सिर्फ इतना ही लिखा हुआ कि ही वाज ए प्रीस्ट। डिस्कशन में सिर्फ इतना ही लिखा हुआ है।
You see, the trial court has believed.
PW1 is one Kasinath Pandey. He stated he is
नहीं
a
ठीक
priest
है,
by
वो तो
profession.
सबमिशन में है। Where is a discussion in the finding of PW11?
Finding में
नहीं है। Trial court has relied upon PW11. Trial court has relied upon 4 witnesses to come to a finding, right? You see, there are 4 witnesses to come to a finding. So far as trial court is concerned, there are 3 witnesses, 9, 10 and 11. 9 and 10 को तो appellate court खारिज कर दिया बोल के interested witness है। Let's accept
So,
it. 11.
They had provided a documentary evidence that was my lord the voter list. And my lord the trial court had considered the same, but the appellate court considered that the aforesaid voter list was prepared after filing of the suit. Therefore, he is denied to accept it.
Maybe you forget it. Maybe that we are not bothered about it. But the priest who has performed the marriage has been examined.
That is my lord 11.
PW11 is the son of the priest who had performed the marriage, and he says that I was present at the time of performance of marriage. Trial court records that the evidence is reliable, and the appellate court is silent about PW11. एकदम चुप।
एविडेंस ये स्टेटेड कि मेरे पिता की 20-25 गांव में जजमान थे जिनकी संख्या करीब 300 है। शादी के बारे में डायरी में लिखा जाएगा। पिता के मरने के बाद वो डायरी मेरे पास है। बाकी वाला के शादी के बारे में उस डायरी में लिखा होगा। मेरे पिता के मरे हुए 10-12 साल हो गए हैं। तब से 60-70 शादी मैंने करा है। सभी शादी के बारे में याद है। पिताजी के 25 साल तक काम से पिताजी के साथ कितने जगह शादी करा है याद है। 16 साल के आयु में पहली बार पिताजी के साथ शादी करने गया। आखिरी पसोई गाँव में पिता के साथ 12 साल पहले गया था। नदिया में 3 जजमान है। पिता के साथ जो शादी करा है उसमें 4 को नाम मालूम है, ये सब नहीं। Otherwise, there is no evidence, apart from
One
the
evidence is
apart from
sufficient.
the 11.
Priest का evidence is more than sufficient. और किसका evidence चाहिए शादी के लिए? He is the best evidence. और उसके अलावा registered deed में लिखा हुआ wife of such and such लिखा हुआ है। मे भी बाद में मरने के बाद उन्होंने ऐसा किया।
But documentary evidence so far is altogether wrong. Even the voter list which was provided.
Maybe voter list बाद में बना। ठीक है, forget about the voter list.
And there are contradictory evidences.
Where is the contradiction?
Appellate court has discussed the same matter. The name of the wife of Mangal Bhandari was not Titubala. That has been clearly stated. This issue, while I am reading the same, this issue is prima facie important for just decision.
Which issue? Which issue? बताइए which issue?
Issue number 3.
Issue number
Appellate
3.
court has discussed the same.
Yes.
Below in its judgment has held Potubala was legally married wife of
Nomita was alive. Nomita was alive.
Momita, for his all the witnesses have stated that Momita was suffering from leprosy and she had died.
कहाँ लिखा है? She has died.
इसी को हम कहते हैं।
कहाँ है discussion that Nomita has died? Where which witness has stated? Where is the finding that Nomita had died?
Admittedly, there is no evidence either of Potubala or Momita with the Gurupada Bhandari of Gurupada
Just
is
a
also
moment, Mr.
production.
Counsel, just a moment.
This
आप issue number 3 appellate court का पूरा पढ़िए.
उसी को पढ़.
This issue is of prime importance.
मैं
The court below in his judgment has held that Pittuwala was legally married wife of Gurupada. इसके बाद पढ़िए. Admittedly, there is no document.
This document was executed as per death of Gurupada.
आपका नहीं मैच कर रहा है. Admittedly, there is no document to prove marriage. है ना?
अगर हम मोहिताबाद है,
अरे फोर्थ लाइन पढ़िए ना
legally
फाइंडिंग का.
married wife of Gurupada. On the other hand, Momita was who is said to
आपका मैच नहीं कर रहा है. आप कहाँ से पढ़ रहे हैं?
हम पढ़
जहाँ
रहे
से
हैं.
फाइंडिंग शुरू हो रहा है वहाँ से फोर्थ लाइन पढ़िए.
फाइंडिंग के इशू नंबर 3
इशू नंबर 3 का फाइंडिंग का फोर्थ लाइन पढ़िए.
fourth line, admittedly there is no document to
Yes.
prove marriage of either Pittuwala or Momita of Gurupada Bhandari. Of Gurupada Bhandari is a deed of adoption executed by Pittuwala claiming herself to be the wife of Gurupada Bhandari. This document was executed as per the death of Gurupada Bhandari, and therefore the admission in deed of adoption cannot be operated as conclusive evidence. Pittuwala was not examined as she died that during the pendency of suit, and therefore her assertion about being wife of Gurupada could not be tested in cross-examination. On the other hand, Momita, who is said to be the legally married wife of Gurupada, was also not produced by the defendant for her evidence. Since present respondent, plaintiff, claims to be adopted son of Gurupada Bhandari by Pittuwala Dasi, it must be proved by the plaintiff that Pittuwala Dasi was in fact legally married wife of Gurupada, as his adoption discloses natural heirs from succession of properties left behind by Gurupada Bhandari. So I will examine the evidence adduced by the parties. So far the evidence of plaintiff witness is concerned. PW1 has stated in his evidence that Pittuwala Dasi family place is close to his house. He has further stated Pittuwala was married with one Mangal Bhandari, a village Bhogi Kata, and she was living with Mangal as his wife. He has further stated that he had visited Pittuwala house several times. He has also stated Pittuwala died at her husband's place. PW2 Sagar Nath Pandit, resident of Bhogi Kata of the village of defendant, has stated in this evidence that Pittuwala was wife of Mangal Bhandari. He has also stated that Pittuwala all along lived with Mangal Bhandari as his wife. He has also stated Mangal had no other wife than Pittuwala. PW3 has stated Pittuwala was wife of Mangal, like in PW5.
Likewise, PW5.
5. Parmeshwar Singh, a man of defendant of the village, has stated he had given marriage of Pittuwala in Mangal Bhandari.
PW5 Parmeshwar Singh, a man of defendant's village,
Man
has
of defendant
stated
village. Yes.
that he had seen the marriage of Pittuwala with Mangal Bhandari.
Mangal Bhandari. He has also stated that Pittuwala started living with her husband in the house of Mangal Bhandari. PW6, who is the true brother of Pittuwala, has stated that Mangal Bhandari was his brother-in-law, being husband of his sister Pittuwala. PW Dhananjay Bhandari, who is allegedly related to defendant, has stated that Pittuwala was wife of Mangal Bhandari. Pittuwala was living with Mangal Bhandari. PW9, Savitri Devi is mother of Pittuwala. She has stated that daughter of Pittuwala was married with Mangal Bhandari. She has stated after marriage of Pittuwala started living with husband of PW10. PW10 is Supal Bhandari. He has stated Pittuwala was wife of Mangal Bhandari. PW11 is one Kasinath Pandey. He has stated he is the priest of the profession. He claims. On the other hand, the defendant has examined 10 witnesses. PW1 Pandit by profession, has stated that he attended marriage of Mangal with Nomita. He has stated Nomita lived with Mangal for 6 to 7 years, but left her husband when he has afflicted leprosy. DW2 Raso Singh, with his claims closer never, Aradhan Bhandari has stated he has attended marriage of Mangal Bhandari, daughter of Mohan Bhandari of village Bajari. He has stated Mohan's daughter had been living with Mangal, but Mangal was afflicted with leprosy. She left him. She went to her father's place. Sri Gopinath Singh has stated he is cousin of Ras Bihari Singh. He has stated Mangal was married at village Bagduri. He has also stated his wife lived with him for 7 years after marriage, but left him after he was afflicted with leprosy. He has further stated Mangal had not married with any other lady. PW4 Sambhu Rai has stated he performs puja. He was priest in Mangal's marriage. He has stated that Mangal was married with a Bagjuri. He also has stated Mangal's wife left Mangal. He was afflicted with leprosy. PW5 Udan Singh has stated Mangal was married in the village Baljuri. He has further stated when Mangal was afflicted with leprosy, his wife left him. Mangal has not married another lady. PW6 Gokul Bandari, Mama of village of Baljuri, where Mangal is said to be married with Nomita, has stated that Mangal was married with daughter of Mohan Bandari. PW7 Arun Bhandari has stated Nomita was married with Mangal Bhandari about 30 years ago. PW9 is nephew of Mangal. He has stated Mangal was married with Nomita and not with Kutu Baladas. Wife of Sunu Hembram has stated that Mangal was married in the village Bajuri. His wife lived for 6 to 7 years and thereafter left her husband. He was approved with leprosy. So far as the documentary evidence is concerned, plaintiff respondent 535 copy of voter list, which was which shows Kutubala as wife of Mangalmani Exhibit 4. The court below has laid much stress and appears to have engaged much in coming conclusion of Kutubala, legally married wife of Mangal Bhandari. The learned lawyer appearing for the appellant contended that the voter list was prepared in the year 1983. Much after filing of suit, the suit was filed in the year 1982 and voter list was prepared in the year 1984, has been made only for a ground for declaration of Kutubala as wife of Mangal Bhandari. He further contended that it in fact Kutubala Dasi was wife of Mangal Bhandari. The voter list prepared prior to filing of suit would have been also disclosed Kutubala as wife of Mangal Bhandari, but no such voter list has put personally been filed. I find much stress in the contention of the appellant lawyer and they have therefore decided if the plaintiff respondent has been called from Kutubala as only married with wife of Mangal Bhandari. So far as oral evidence is concerned, I have already demonstrated above. Now we need to scrutinize the evidence of both sides. On the other hand, 10 witnesses of plaintiff respondent PW1 stated Kutubala Dasi died at her in-law's place, where PW6 Kartik Bhandari, own brother of Kutubala, has stated he had last from Kutubala at the house of posted at Bhandari. PW9 Savitri Devi, mother of Kutubala, has stated that Kutubala died in her husband's house. PW10 Super Bhandari in the evidence has stated, they admitted that Kutubala died in his house. And he has stated living there 6 months before her death. Thus, I find the plaintiff's witnesses keep the weightage about the place of death of Kutubala. It is admittedly the case of plaintiff respondent that Ajay Bhandari, alleged adopted son, is natural son of Super Bhandari. No, where from might have been high interest in seeking the adoption of the high or son Ajay Bhandari by Putubala is co-signed by society as well as by law. Putubala was sister his son-in-law, and it was easier for him to bring Putubala in his coalition. PW6 is the brother of Putubala, PW8 Dhananjay Bhandari is nephew of Supal, PW5 Savitri is mother of Putubala, PW10 is Supal Bhandari is father of adopted son of Ajay Bhandari. So all the four witnesses are highly interested witnesses. This is not a simple case of deposition, but it involves the question of ownership of considerable properties. In that light of things have been examined so far, other witnesses are concerned, I find that P.W. Santo Das is merely a chance witness. His assertion of Putubala died in his lifeless is contradicted by the evidence of Supal Bhandari in whose house Putubala died. P.W. 9 is not the witness point of marriage. He has simply stated Putubala was with
You said that Nomita was dead. कहाँ है finding? You said that there is a finding that Nomita had expired. That is why she did not come forward to depose. Where is that finding? It's not there. You have read it fully. नहीं है ना?
तो नहीं है, लेकिन मंगल भंडारी
क्यों नहीं लेकर आए उनको? A person who is alive, you don't bring her. And there are people who are saying that they have been living as husband and wife. PW11 का finding, PW11 का कोई discussion नहीं है finding. Rest of the witnesses जो close member, family members हैं, you discard them as interested witness. Close family member नहीं आएगा बताने के लिए तो कौन आएगा शादी हुआ? Yes? The persons who are close family members, they would only come to say yes, there was marriage. Merely because a person is an interested witness, will you throw it into the dustbin? What interested witness? How are they interested so far as adopted son is concerned? How will they be interested with respect to an adopted son? Tell me. ये भी नहीं है कि उसका बच्चा था वो सोची कि चलो हड़प लेते हैं, ऐसा भी नहीं कहानी. नहीं है ना? PW11 के एविडेंस का कहीं कोई डिस्कशन नहीं है. Therefore, the appreciation of evidence is not in accordance with law. One witness has been completely excluded, and he is such an important witness. And this lady who was the first wife never came forward to claim that she is the first wife. Adoption कब का है? What is the date of adoption?
21st October 18.
Sorry, 21
October
10 1980. When was the suit filed?
It was filed in 1982.
1980. And the court says that mere living as husband and wife is not sufficient. What else is sufficient? हम लोग का marriage certificate है क्या? Do we have in society our generation marriage certificate? Do we have marriage certificates? आपका है? You have? मेरा तो नहीं. So marriage, you are looking for documentary evidence of marriage. What documentary evidence of marriage are you looking for? And it has come that they have been living as husband and wife. The court also says that mere living as husband and wife is not sufficient. The first wife, भाई at best second wife का story बना रहे हैं आप, ठीक है? First wife who is not dead, she has not come forward to depose that she is the wife. She would have been the best evidence. A man may maintain and keep a kept or mistress, but she will not acquire the status of wife. Just tell me one thing. Is there any finding that Namita was the first wife? There is no finding. Yes? Mr. Counsel, is there any finding that Namita was the first wife? No finding. In absence of such finding, a man and a woman are living together as husband and wife is not sufficient to prove marriage. And the priest is also coming forward and saying that yes, I had seen the marriage. My father had performed the marriage. I am an eyewitness to the marriage. His evidence is not considered. लिखिए सर. Heard the learned counsel appealing on behalf of the parties. This appeal was admitted for final hearing by order dated 9/3/1994 on the following substantial question of law. Quote, whether the finding of learned appellate court is vitiated for making out a third case beyond the pleadings of the parties and the reasons assigned by the appellate court in reversing the judgment of trial court are not tenable in the eyes of law. The learned counsel for the appellant, while giving the background of the case, has submitted that the suit was filed by Patuwala Dashi, claiming half share of the suit property. However, during the pendency of the case, she expired and Ajay Bhandari was substituted as adopted son and adoption was by way of registered deed of adoption. Dated 21/10/1988.
81.
Sorry,
81.
1981.
81.
21/10/1981.
Exhibit 2.
Exhibit 2, which was prior to the filing of the suit, and the suit was filed in the year 1982. The council has further submitted that during the suit, a plea was raised that Pitubala Dasi was not the legally married wife of Haradhan
Gurupada alias Mangal.
or Gurupada
Alias Mangal.
alias Mangal,
That is his brother.
and therefore the adopted son also did not acquire any right over the suit property. He has submitted that the registered deed of adoption was also challenged. He has further submitted that the trial court framed the following issues for consideration. And all the issues, the issue number 1 was not pressed, and the court found no defect in the frame of the suit, which was answered accordingly. And all other issues were decided in favor of the plaintiff, who was accordingly given the share in the suit property, by holding that Ajay Bhandari was entitled to half share of in the properties described in Schedule A, B, and C of the plate. The learned counsel submits that the finding with regard to the marriage of Pitubala Dasi with Mangal Bhandari has been recorded in paragraph 4 and 5 of the learned trial court's judgment. And the ultimate finding is recorded in para 8. the defendants failed to prove that Nomita was the wife of Mangal Bhandari, and there was enough evidence on record to show that the Pittuwala Dasi and Mangal Bhandari were living as husband and wife. He has also submitted that the witnesses who had seen the marriage were PW 9, 10 and 11, and 11 was the son of the priest who had performed the marriage of Pittuwala with that of Mangal Bhandari. The Learned Counsel submits that the trial court decreed the suit, and so far as the Learned First Appellate Court is concerned, the same issues were considered, and even the First Appellate Court did not record any finding that Nomita was the legally married wife of Mangal Bhandari. However, the First Appellate Court rejected the evidence of PW 6, mother of Pittuwala, PW 8, has rejected the evidence of PW 6, 8, 9 and 10 by observing that they are interested witnesses. The Learned First Appellate Court has recorded the submissions with regard to PW 11 also, but while giving the finding, there is no discussion of the evidence of PW 11. And the Learned Court has also observed that no evidence was laid by the plaintiff to show that any religious or customary usage was performed. The Learned Court also recorded that merely because a man was living, two persons are living as husband and wife, that was not the sufficient requirement of law. And further observe that this would not acquire the status of, just living together will not acquire the status of wife. The Learned Counsel have also submitted that so far as the adoption is concerned, the adoption was held to be valid except to the extent that the description in the adoption deed that Pittuwala Dasi ki Devi, Pittuwala Devi, Pittuwala Dasi was husband of Mangal Bhandari. उतना बार तो डिलीट कर दिया.
was the wife of Mangal Bhandari.
Sorry, was the wife of Mangal Bhandari. The Learned Council has submitted that the Learned First Appellate Court has committed illegality to the extent of perversity in not considering the evidence of PW11 and also the consistent evidence on record that Pittubala and Mangal Bhandari were living as husband and wife. He has also submitted that the evidence of close relatives have been discarded merely by saying that they are highly interested witnesses by the Learned First Appellate Court. The Learned Council has also submitted that the Learned Trial Court, while coming to a finding that Pittubala was living at the house of Mangal Bhandari as his wife, has also referred to the judgment of the Honorable Supreme Court reported in AIR 1978 SC 15, क्या number है इसका? Wherein it was held that citation नहीं पता चला. Wherein the Learned Council has also submitted that the Learned Trial Court had considered the materials to on record to hold that if man and women are living together as husband and wife for a long time, there is a presumption that they were legally married. The Learned Council has submitted that although the defendants claimed that Momita was the legally married wife, but she was still alive, but no steps were taken to examine her, and no attempts were made on behalf of the contesting defendant to bring her to the witness box in support of their case that she was the legally married wife of Mangal. He has also submitted that the learned trial court also referred to the evidence of DW9, paragraph 5, the learned trial court had rejected the plea of the marriage of Mangal Bhandari with that of Nomita, and ultimately held that Batulal was Bitubala was the legally married wife. But these aspects of the matter has not been considered by the learned first appellate. So far as the first part of the substantial question of law with regard to as to whether the first appellate court has made out a third case and beyond the pleadings is concerned, the learned counsel has submitted that he has nothing to say in this connection, as the point regarding adoption of Ajay Bhandari and marriage of Pitubala with इसके हस्बैंड का नाम भूल जाते पिट्टूवाला का क्या नाम है
Bhandari alias Gurupada.
पिट्टूवाला's husband is
Gurupada Bhandari alias Mangal.
अच्छा गुरुपद भंडारी was under dispute, and accordingly he submits that these issues were rightly entered into, but the learned first appellate court has committed perversity in reversing the judgment passed by the learned trial court, and therefore the reasons assigned are not tenable in the eyes of law. The learned counsel for the respondents has opposed the prayer and has submitted that the learned first appellate court has considered the fact that the learned trial court had heavily relied upon the voter list which was prepared after filing of the suit, and has considered the materials on record while reversing the finding of the learned trial court with regard to marriage of Pittuwala with Mangal with Gurupada Bhandari alias Mangal, and The finding of fact recorded by the learned first appellate court neither suffers from any illegality nor suffers from any perversity, and therefore the finding does not call for any interference. यही है तो छूटा आपका. After hearing the learned counsel for the parties, इनका ना पिटू वाला का नाम, उसका हस्बैंड का नाम ठीक से रिकॉर्ड से मैच करके ना एकदम यूनिफॉर्मिटी के साथ. This court finds that a suit for partition was filed on 4/6/1982 by the original plaintiff Pitubala Dasi, seeking half share in the suit property. However, she died during the pendency of the case on 2/6/84, and Ajay Bhandari was substituted in her place by the order dated 10/2/86. The case of the original plaintiff was that parties are governed by Dayabhaga School of Hindu Law, semicolon. One Radha Raman Bhandari was recorded tenant of the land or of the suit property, who died sometimes in 1946, leaving behind two sons, namely Haradan Bhandari and Gurupada Bhandari, as his only heirs. Wife of Radha Mohan Bhandari had predeceased him, semicolon. After death of Raman Bhandari, his sons came in possession of the property jointly and continued to be so till the death of Gurupada Bhandari in 1981. ये appellate court का judgment के para 2 से लिया गया. The specific case of the plaintiff was that Gurupada Bhandari died leaving behind his wife Patubala Dasi, who claimed to be the legally married wife of Gurupada Bhandari and claimed to have been living as his wife. After death of Gurupada Bhandari, she had adopted Ajay Bhandari. In October 1981, after completing all the necessary formalities, and a registered deed of adoption was executed. The adoption was done on 21/10/1981. The plaintiff claimed that Haradan Bhandari started creating disturbance, and consequently she demanded partition, and ultimately she filed the suit, and after her death, her adopted son Ajay Bhandari was substituted. The defendant Haradan Bhandari also died during the pendency of the suit, and his heirs were substituted by the order dated 10/8/1983. The substituted defendants Kinkar Bhandari filed his written statement, and other defendants did not appear to file written statement. Did not file written statement. The main case of the defendant was that Patubala Dasi was not legally married wife of Gurupada Bhandari, and she all along lived at her father's place in village Meghia. She was afflicted with leprosy since childhood, It was therefore the case that Gurupada Bhandari was married with one Nomita Bhandari, daughter of Mohan Bhandari, about 25 years ago. And Nomita was living with Gurupada as his wife. And after some time, when Gurupada Bhandari became lunatic and attacked by leprosy, Nomita Bhandari left her husband left her husband's place soon thereafter. It was their further case that Gurupada Bhandari was receiving his treatment of leprosy, where he met Patubala Dasi, who also used to receive treatment of leprosy. And it was their further case that one Sufal Bhandari brought to Pittuwala Dasi in his collusion, got a sham deed of adoption in existence only in order to grab the land of Gurupada Bhandari. And that Pitubala Dasi is sister of one Ganesh Bhandari, who is the son-in-law of Supal Bhandari. Thus, the defendant's case was that Pitubala Dasi had neither any right to execute the deed of adoption dated 21/10/81, nor she had executed any such document. And the case of the defendant was that all the properties were owned and possessed by Radha Raman Bhandari, the common ancestor of Haradhan and Gurupada. The issues framed by learned trial court as well as considered by the learned first appellate court were one and the same. The issues framed by the learned trial court has already been quoted above. The learned trial court held the deed of adoption valid, also held that the defendants had failed to prove that Nomita was the legally wedded wife of Gurupada Bhandari, and further held that Vitubala was the legally married wife. While so far as the learned first appellate court is concerned, on the point of adoption, the learned first appellate court held that the adoption was valid only to the extent that Vitubala had adopted Ajay Bhandari in her own capacity and not as a wife of Mangal Bhandari. ऊपर ना एक एलियस नाम दे देंगे, मंगल भंडारी and this Gurupada Bhandari. However, so far as marriage with Momita is concerned, the learned first appellate court also did not record any finding that she was the legally wedded wife of Mangal Bhandari. However, the plea of marriage of Pitubala with Mangal Bhandari was disbelieved by the learned First Appellate Court by recording that PW 6, 8, 9 and 10 were all interested witnesses. PW 6 was the mother of Pitubala. PW 8 was the nephew of Surfan. PW 9 दो बार आ गया मदर ऑफ Pitubala. PW 9 PW 10 6 is
6 is brother.
अच्छा 6 is brother. ठीक है.
Nine is
PW 9 is mother.
Yes.
PW 10 is father of the natural father of the adopted son Ajay Bhandari, who had supported the marriage and also the adoption. So far as PW 11 is concerned, the learned First Appellate Court has recorded that PW 11 is one Kashinath Pandey. He has stated that he is a priest by profession and his father was the priest in the marriage of Pitubala and Mangal, and he claims to have attended the marriage. His witness, though recorded, has not been considered by the learned First Appellate Court. This court finds that 1. The learned First Appellate Court has considered the eyewitnesses of the marriage in paragraph 4. Paragraph 4 is the in paragraph 4 of the trial court judgment, which is quoted as under. And further, and while considering the point of marriage, the learned court has considered the evidence of PW 9, 10 and 11, who were the eyewitnesses to the marriage. And has recorded that all the 3 witnesses were cross-examined at length, but their evidence on the point of marriage has not been successfully shaken in the cross-examination. The learned, इसको quote करना है, the learned trial court also considered the evidence of PW 1, 2, 3, 5, 6 and 8, who had deposed that Pitubala and Mangal were living as husband and wife. And recorded that the evidence of the defendants was discussed right from paragraph 6 and was ultimately recorded by the learned court that the entire evidence used on behalf of the contesting defendant in support of their case was that Mangal was married with Nomita, the daughter of Mohan Bhandari of village Bhagriji. पैरा 7 के का लास्ट वर्ड है, देखिए तो क्या है. The learned trial court ultimately held that Nomita was not the legally wedded wife of Mangal Bhandari. लिख के दीजिए ना प्लीज, लिख के दीजिए, पढ़ा नहीं. This court finds that the learned first appellate court, while considering the point of marriage, had also referred to the name of Vitubala Devi in the voter list as wife of Mangal Bhandari. But the fact remains that not only the eyewitnesses to the marriage, but also the witnesses who had seen Vitubala Dasi and Mangal Bhandari as living together as husband and wife were considered to hold that Vitubala Devi was not, Dasi was the legally married wife of Mangal Bhandari, and the defendants failed to prove that Nomita Bhandari was married to Mangal Bhandari at any point of time. The first appellate court, while considering the evidence of while considering the trial court judgment, has observed and agreed with the submission of the counsel for the defendant that much reliance was placed by the learned trial court on the voter list which was prepared after the filing of the suit. However, this finding is not correct in view of the fact that the perusal of the judgment passed by the learned trial court reveals that the finding regarding marriage of Mangal Bhandari with Vitubala Dasi was primarily based on the oral evidences reduced on behalf of the plaintiff. As recorded in paragraph 4 and 5 of the trial court judgment, and the evidence of the defendants were recorded and considered in paragraph 6 and 7. The learned first appellate court has completely ignored the evidence of PW11, who was an independent witness, and it was his father who had performed the marriage, and he was also eyewitness to the marriage. while considering the point regarding presumption of marriage on the ground that the man and woman has been living as husband and wife is concerned, the learned first appellate court was of the view that mere living together did not help the plaintiff in any manner, and no evidence regarding religious or customary usage was performance of custom was led to prove the marriage. And the learned first appellate court also recorded that a man may maintain a kept or mistress, but she cannot acquire the status of wife inverted comma medallion. Although it was nobody's case that Pattuwala Dasi was just living with Mangal Bhandari as a kept or mistress. This court finds that the learned first appellate court has committed perversity in coming to a finding that Vittuwala Dasi was not the married wife of Mangal Bhandari and has not even met with the reasons given by the learned trial court in an appropriate manner and has completely ignored the evidence of DT.11 an independent witness to the marriage. Accordingly, the finding of the learned first appellate court that Vittuwala Devi, having held as a person, the finding of the learned first appellate court that Vittuwala Devi was not the legally married wife of Mangal Bhandari is set aside, being perverse. Consequently, the finding of the learned first appellate court that the adoption, deed of adoption, though valid, was only in her own capacity and not as a wife of Mangal Bhandari, is also incorrect. Consequently, the judgment passed by the learned first appellate court is hereby set aside, and the finding and the judgment passed by the learned first of the trial court is upheld. Allowed.
Under heading for orders with defect, item 12, second appeal 253 of 2016.
It's time to cut both fees there.
क्या डिफेक्ट है?
Both fees there by this is
एक बार आपका डिस्मिस हो चुका है।
उसमें लोअर कोर्ट का जजमेंट देना था सर्टिफाइड कॉपी, उसके बाद फर्दर डिफेक्ट्स
ये तो एक बार फिर हो चुका है आपका। It will be dismissed without reference to bench. Remove the defects within 8 weeks. Failing which this appeal shall stand dismissed without further reference to bench. तो ये दोबारा कैसे लिस्ट हो गया? बताइए। 20/8/24 के बाद ये दोबारा कैसे लिस्ट हो गया?
फर्दर स्टैंडर्ड प्रोग्राम डिफेक्ट रिमूव करने के बाद
अच्छा। Essay number 253 of 2016. The learned counsel for the appellant raised for and is granted time till 25th of August 2025 to remove the surviving defects or to file any petition in connection with one or the other defects, failing which this appeal shall stand dismissed without further reference to bench. If this order is complied, close this case under appropriation on 27th of August.
Item 13, second appeal 289 of 2016.
Defective है?
Yes,
Same order per the time till 25th August is granted to the applicant to remove the surviving defects, claim free, और एकदम सेम तरह का ऑर्डर करिए और 27th को लिस्ट कराइए for the applicant,
yes sir.
counsel for the applicant. 2 weeks I have given you.
Leadership has been for 4 weeks.
2016 का केस में 4 हफ्ता का 4 साल दे दें आपको?
Leadership actually contact नहीं हो पा रहा था
तो
client.
अच्छा है, कांटेक्ट नहीं होगा तो डीएफडी हो जाएगा।
Item
How
14,
many years
second
have
appeal
passed? 2016 का अपील है सर। What are you doing? क्या पता जीवित भी होंगे कि नहीं। चलिए कॉल करो।
Item 14, second appeal 691 of 2016.
ये जितने ऑर्डर है ना, कंप्लाई नहीं हो तो दोबारा लिस्ट में नहीं आना चाहिए, ठीक है? In view of the office note, let this second appeal be listed on 8th of September. 8 September को भी होगा, 22 September.
Item 15, second appeal 432 of 2017.
Defective है?
Yes.
litigation for 3 weeks time. We have to file CC of the impugned judgment, and it's a company matter, so we have informed him today regarding this.
2017 से आपको CC of impugned judgment नहीं मिला?
I saw
There has
the
been
fixed-
preemptory order earlier. The case was dismissed. It was restored. What are you doing?
We have
It should be dismissed right away. You are not interested in the case.
Your Lordship, we have informed today itself. Your Lordship, I had verified the defects today morning, and we have sent them on mail, Your Lordship, regarding it. And also there is a limitation petition to be filed.
Limitation also you do not file.
45 days limitation is the limitation.
45 days.
Limitation is there.
That also you have not filed, no?
I have informed them today. By way of last indulgence, 3 weeks may be granted, Your Lordship.
Same order कर दीजिए. 25 तारीख तक है preemptory order.
Pardon me,
25th तक preemptory order है फिर 25th. ऐसा करिए और yes 20 same order. कहाँ चले गए वो? It's a preemptory order to remove the defects by 25th.
3 weeks may be granted, Your Lordship.
Rejected. Post on 22nd तक आपको.
Item 16, second appeal 518 of 2017.
There are two IAs.
Sorry.
IA number 7529, which is sending the decree and the appeal,
IA for
sending the decree to the High Court.
391139.
D729.
Sorry. आपका तो 8 वीक एक्सपायर हो गया.
उसमें तो आप 1139 for
आइए
extension,
बताइए कहाँ है आपका आइए.
for extension of 8 weeks.
Where is your IA for sending the decree? IA 7259. Which IA is that?
759.
752. IA number 7529 of 2023. The learned counsel for the appellant has submitted that this interlocutory application has been filed with a prayer to send the decree under appeal to the learned district judge Roman 3 at Jatra for correction in the decree in the address of appellant number 11 within bracket C and appellant number 12 and respondent number 3 because their address are missing in the decree under appeal. Office is directed to send the decree passed by the first appellate court to the concerned court for correction. Along with a copy of this order. Post this case on 13th of October. Review of the aforesaid circumstances, IA number 1139 of 2025 seeking extension of time to remove the defects as pointed out by the office is allowed and the appellant is permitted to remove the defects within a period of 4 weeks from the surviving defects within a period of 4 weeks from the date of और कौन सा defect आपका छूट रहा है? What all defects are remaining to be removed? The appellant is directed to remove the surviving defects by the next prior to the next date of hearing. ठीक है? हो जाएगा? Preemptory. Later portion is preemptory.
Item 17, second appeal 595 of 2017.
This is also defective. Time till 25th August is granted to remove the surviving defects or to file an appropriate application with regard to one or the other defect. If this order is preemptive, if this order is complied, within time, close this case on 27th and appropriate.
Item 18, second appeal 238 of 2018.
Any defective?
Yes.
Same order continue.
Item 19, second appeal 239 of 2018.
One defect with respect to execution of signature of this appellant member,
Sorry, one defect regarding
execution of appellant execution at wakalat number
of by
Monu Jha, appellant number 4.
the file an IU to that effect.
No, idea is there for substitution and conservation of delays. What has happened in this case, madam, that
This defect number 1, additional execution of Mr. Abhijit Kumar Jha has been at Wakalatnama.
it's Abhijit Kumar Jha alias Monu Jha. There is a correct. So I pray that it will be removed.
ऐसे नहीं आगे नहीं करना था. ऐसे वकालतनामा में डिफेक्ट ऐसे नहीं रिमूव हो सकता. एलियस आप कहाँ से, आप ये एलियस नेम कहाँ से लेके आते हैं?
डिग्री में ये मौजूद है.
हाँ, सर. तो ये आपका नाम एक नया नाम हो तो कौन आप हुआ नहीं? एलियस नेम कहाँ से आ गया?
वो
डिग्री में नीचे कोर्ट में बोले हैं आपका कोई एलियस नाम है?
नीचे
तो फर्स्ट एलियस, सेकंड आप उसके बाद एक तो तीसरा एलियस नाम आएगा. ऐसे नहीं, इट कैन नॉट बी इग्नोर्ड लाइक दैट. फाइल योर इंटरलोक्यूटरी एप्लीकेशन. और जब तक अदर साइड अपीयर नहीं होगा आपका ये सब डिफेक्ट रिमूव नहीं हो सकता. एलियस नेम ऐसे नहीं दिया जाता है ना. दैट इज नॉट द प्रोसेस. क्रिमिनल केस थोड़ी है कि एक तो एलियस के साथ एलियस जोड़ के चले जाए. You have to file your interlocutory application with proper proof about your parentage or whatever. नहीं तो नहीं होगा. आपका आइडेंटिटी प्रूफ आपको देना पड़ेगा. ऐसे एलियस नेम से नहीं चलेगा. ऐसे नंबर 239 of 2018. With respect to defect number 1, the learned counsel for the appellant pays for some time to file appropriate interlocutory application. He submits that the defect regarding alias name in the wakalatnama be ignored.
regarding additional execution
Additional execution.
of different
Sorry?
terminology यूज किया गया है उसमें स्टैम्प रिपोर्टिंग में. एग्जीक्यूशन में भी वेरीफाइड.
Yes, तो आप उसका फाइल करिए. Alias name छोड़ दीजिए with regard to defect number 1 का. अब you file your appropriate application. Needful be done by 25th. Post this case on 27th.
2 weeks.
काफी है 2 हफ्ता.
Item 20, second appeal 185 of 2019.
There are several defects to remove 4 weeks time.
आपको पहले भी टाइम नहीं दिया, सेम ऑर्डर करिए 25 तारीख को।
Item 21, 2nd April 26 of 2020.
What is this?
In this case, defect number 2 was pointed out to the fact that in your code, the represented by power of attorney. File the power of attorney, but meanwhile, the sole appellant, he has died, so power of attorney now has not been effect. So I filed petition for substitution of the heirs of sole appellant.
There was any dispute regarding power of attorney?
No, not power. Power of attorney has to be filed because they have he was represented before the court below.
So therefore we have to see, was there any issue regarding power of attorney? The person has died, but the power of attorney has not died.
No, power of attorney ceases after the death
That's
of the
right,
power.
but you file it, what's the problem about
No,
it?
how can I file it? Power of attorney of a dead person. It will not be returned to him even if he is dead.
It must have been filed before the learned trial court.
On trial court, it can be come
Was
with
there
a-
any objection regarding power of attorney? Was there any issue framed regarding power of attorney?
No, power of attorney is not there.
Issue अगर होगा तो कोई बात नहीं.
There are 8 issues.
What was the case about? Which is that exhibit power of attorney का exhibit कौन सा था? Original power of attorney. Exhibit 7. वो तो कोर्ट में ही फाइल हुआ होगा.
No,
It must be lying in the court.
रहना चाहिए कोई. It's the record of the court.
It's a record of the court, no? It must be there in the court. The learned counsel for the appellant has referred to defect number 2 and has submitted that as per the defect, the power of attorney is required to be filed. The learned counsel submits that the executor of power of attorney has expired and a petition for substitution has been filed before this court. Before this court, and further, as per the order passed by the learned trial court, it is apparent that original power of attorney was filed as Exhibit 7 before the court. He submits that the original power of attorney must be lying before the court concerned. Considering therefore, he submits that the defect number 2 may be ignored for the time being. Considering therefore submission, defect number 2 is ignored for the present. और बताइए क्या है आपका? What else?
Substitution of sole appellant.
This is the IA you have filed for that purpose. IA number 11.08.2025. Seeking, ignoring the defect. नहीं, ये तो नहीं है.
Substitution.
It's a substitution. नहीं. Okay, the said defect is ignored for the timing. Yeah, ये क्या है? Substitution.
Yes.
And who has expired?
Sole appellant.
Sole appellant. Is there any other defect? When did he die? When did he die?
Died on 18th January 24.
Is it within time?
Not within time, but
This is IA for substitutions. Okay. IA number 11.00.24. The counsel for the appellant has submitted that this petition has been filed under Order 22, Rule 3 and 9 of CPC, seeking to setting aside abatement, if any, condonation of delay in filing the petition for substitution. He submits that the sole appellant has expired on 18/1/2024. He has given the names of legal heirs and successors in paragraph 4, within bracket, in paragraph 4 of the interlocutory application. Issue notice to the respondents on the aforesaid interlocutory application, for which requisites be filed by the appellant within a period of 10 days from today under ordinary process. They are all living in Jharkhand.
Yes. All go
Post this case on 13th of October, awaiting service.
Item 22, second appeal 42 of 2022.
Time to remove the defects. What all defects are there?
Court fee of rupees 240.
आपका तो पहले DFD नहीं हुआ. All defects pointed out have been removed. आपका डिविडेशन पिटिशन में 5461 डेज का डिले. आप देख लीजिएगा भैया, ऑफिस नोट देख लीजिए और सेम ऑर्डर कर दीजिए वो 25 तारीख. These orders are all pre-entry orders.
Item 23, second appeal 189 of 2020.
Defective.
Yes.
तो ये दोबारा कैसे लग जाता है? Ignoring defect number. Submit date. Anything urgent? ऐसा कुछ नहीं है ना कि किसी चीज़ के लिए बैठे हो, आप किसी चीज़ के लिए बैठे हो.